I'm John Leonard. I'm a corporate lawyer with Fairfield and Woods in Denver, Colorado. We're doing a video series on different aspects of the law so our clients can see what we're up to and get educated on various areas of the law, including raising money for companies, receiverships. Today, we're talking with one of my colleagues, Tim Jordan, about wills and trusts. We just did one video on wills. You'll want to see that. But I guess most of the time, Tim, you don't do wills, you do trusts. What is a trust?
The trust basically can be looked at kind of as a will substitute, and trusts are very commonly used now, whereas 40 years ago people used a more traditional last will and testament. And there are some significant advantages over a trust-based plan as opposed to a will-based plan. Essentially, you can accomplish the same thing. It dictates how your assets are distributed on your death, and so it shares that attributes with a will. The trust has some significant advantages over a will, but a lot of people don't know is when someone passes away, a will gets filed with the court, and at that point in time, it becomes a public document. And I think we've all seen some celebrity pass away and a month later you're reading their will on the internet and you wonder, well, how did that get up there? And the reason is once it's filed with the court, it's public. So theoretically, your nosy next door neighbor could go down to the court and say, I want to see John's will. And they'd say, here, go ahead and make a copy of it.
And if you help me do a trust and I change my mind on something, I can always come back in and change it before I die, obviously.
You can. There's a lot of different types of trust, but everybody typically needs what's called a revocable living trust. There are other types of trusts that we use for more complicated gifting and estate tax planning strategies. But a revocable trust, as the name implies, is something that you can revoke it if you don't want it anymore, and you're free to change it at any point in time.
What are typical times that people come in and want to revise their estate planning documents?
Oftentimes it's when they're changing people that they've named. So in a trust document, you're typically the trustee of your trust during your lifetime, and then you name successor trustees. So oftentimes people make that change. Maybe their kids are older and it's now appropriate for them to name their kids. That's a common change. And sometimes we make changes, based on changes in the estate tax laws. So, those are probably the most common changes that we make.
What about divorce?
That's a big one. Generally speaking, if you get divorced under Colorado law, your divorced spouse is automatically out of your estate plan. So that's good because a lot of people get divorced and after getting divorced, they have lawyer fatigue and oftentimes they don't come in and revise their plan immediately. But, any big change in circumstance is a good opportunity to look at your estate plan and make sure everything still makes sense, whether it's divorce, additional children, grandchildren, significant changes in the size of your estate. Those are all good indicators of time to come.
Are trusts probated? Do people have to go to court, or after somebody dies, does the trustee just procedurally, what happens?
So one of the advantages of a trust is, in addition to the privacy features, a revocable trust on death does not get filed with the court. So the will gets filed with the court, a trust does not. So a lot of people don't realize that, and they like the idea of the privacy feature, knowing that somebody can't come in and request their trust from the court and read it and see what you've done with your family. I mean, most trusts don't have a lot of family dirt in them, and they generally don't speak of the size of the estate or specific assets. But sometimes trusts do address a child's substance abuse problems, things like that people would.
Can a trustee take over immediately on death?
They can.
And you would advise that trustee if you've done the work drafting the trust, then you would help whoever that trustee is?
More often than not, because we're familiar with the family, the assets, the planning that was done, and more often than not, we are involved in the trust administration after a death and advising the trustee in terms of what needs to be done.
Can a beneficiary change the terms of a trust?
Generally not. There are some provisions in the Colorado Trust Code that gives us some flexibility to do some things we weren't able to do in the past. But generally speaking, they can't make changes.
So when you help people draft a trust, you caution people if they're getting maybe too detailed about how their beneficiaries can receive money or act or whatever?
It's pretty well laid out, but one of the things that we try to do is to build some flexibility into the trust because some of these trusts last for multiple generations, and whereas the client's children may be a known quantity, if these trusts are going to last for successive generations, then we want to be able to deal with things
Sure.
that may come up 50 years from now.
Great. Well, we've been talking today with Tim Jordan about wills and now trusts. We're going to talk about different aspects or different trends that are coming up in estate planning with Tim in another tape. Thanks for joining us, and please look at the series on our website. It has a lot of different topics you might find interesting. Thanks for joining us.